Happy Monday. How are we
Happy.
doing?
Hello.
Hi, Jay.
Not the daughter.
Hi, Jackie. Hi, John. I got my J's going on today. Yay. Good to see you all. We're going to give it another minute. We're just getting everybody logged in. Dual agency. It looks like I've spooked everybody now. Either that or they're actively out writing deals tonight. So we're going to go ahead and give it just one more minute. Kyle, good to see you. Sarah, thanks for jumping on early. And let's go ahead with our Movement Mortgage Minute. Deanne, want to go ahead and get us started?
Thanks, Rochelle. It'll be short and sweet. Interest rates are in the range of 6.875 to 7.25 FHA conventional. And if you're lucky enough to get a jumbo loan, you can improve that by about 0.5%. So that's the update today.
Okay.
Thank you.
Thanks for the update. And my goodness, we're at least holding steady is what it sounds like.
Yeah, it's
Last
pretty
week.
steady. Yes.
Okay. Awesome. Well, you're welcome to stay if you'd like, Deanne. We appreciate your support with our relationship between Best Choice and Movement Mortgage. Movement Mortgage is still getting deals done for us, and they're doing it in a record time, which is great, and very efficient processing. That's what I've seen recently. So thank you for that. We're going to talk tonight about the do's and don'ts of dual agency. And it was interesting because I went back and looked at some past materials, past recordings, and I'm trying to rack my brain with Shannon, trying to see if we have ever covered the do's and don'ts of dual agency. And this would be a new one for us. So with all of our discussions with the new contracts, I felt it was very necessary that we covered dual agency in addition to a little bit of review maybe for some of you. So I will be going over some case law, and I will be going over some of the fundamentals, maybe some review. But I would say that there were some very seasoned brokers that came into Best Choice Realty when we were doing the contract rollout. And they were like, wow, it looks like we need a refresher on some dual agency situation. So we're going to cover that today. If you have questions or concerns at all, you can just send us a chat. We'd love to hear from you and certainly handle any one-offs that we need to deal with tonight. So we are going to go forward with that. Let's go to the next slide, Shannon. So I think it was interesting, the Seattle Times back in 2020, January of 2020. So, I mean, that was the COVID years, if you guys remember. But home sellers and buyers in Washington, they did an article that says that we are not doing a good enough job in properly working with the consumers. The highlighted portion is the most important point that I want to bring up tonight, which is the local residential real estate leaders dispute the conclusion, but this group, they did some surveys on our agency pamphlet with the state of Washington, and they said that we are the nation's worst, stating that the paperwork is confusing, that brokers are not upfront with their consumers about conflicts of interest, and that 7 pages, which is quite lengthy, written by attorneys. And so there has not been a lot of revision to the law of agency pamphlets. It still carries a lot of information, and you still are required to provide that to your buyers and your sellers. But even with this nonprofit group that did the survey, it would be interesting to note that, you know, it's a nonprofit watchdog consumer advocacy group that really kind of looked at our state, showing it as the worst in the country. There are states on the West Coast that still allow dual agency. Idaho does not allow for dual agency. They have a different way of handling things. So if you are listening and you're licensed only in Idaho, this recording will not apply to you, because I'm going to talk about the Washington State dual agency from the standpoint of what you can and cannot do, and some of the pitfalls and what to look out for. We're going to discuss that tonight. But I thought that was fascinating that Washington, that we're not doing a good enough job, according to an advocacy group. Back in 2011, it doesn't sound like we were doing so well either with dual agency, and they considered it double dipping, still a risky business, according to a National Association of Realtors survey that was done with attorneys and brokers. Agency representation ranked very high. In fact, it's still probably the most, I would say, disputed and litigated item on the table. In fact, I just got done going to a court case that had a lot to do about dual agency. It was a big portion of case law that I ended up being a witness for between our broker and a consumer. So I know that this comes up probably more than you want it to, but more than 57% of the people surveyed back in 2011, I would anticipate that went up substantially, cited that the legal disputes of dual agency was one of their top 3 issues. So it's unfortunate we don't have like 50, 60, 70 people on this webinar. We have less, and that just goes to tell you that maybe real estate brokers like this double dipping, and it is allowed in the state of Washington to be a dual agent. But I wonder, and Shannon and I wonder, are we really doing a good job at making sure our brokers at Best Choice Realty know how to handle both the buyer and the seller, and what those situations, what kind of the risks that are associated with doing that. So I thought about 3 common scenarios that we hear a lot about. In fact, just this last week, I had a question about an open house opportunity and how we handle our buyer agency agreement and who represents whom when it comes to the open houses. And so I'm going to go through the 3 common scenarios. The next slide, I actually have the first page of the purchase and sale agreement. But can a listing agent, and let's say Shannon and I had, Shannon had her listing go up on the market, and let's say that Jane, who is also a Best Choice Realty agent, maybe she did the open house for Shannon. Shannon's the listing agent in that case scenario. And Jane went out to go out and do the open house for Shannon. Would that be a dual agency situation? And the answer is no, it is not. Jane clearly would represent any buyers that would be coming through. The Shannon would have had the exclusive listing agreement, the rights to represent the seller. So that's not a dual agency situation when 2 non-managing brokers or 2 non-designated brokers are on one side or the other of the sale. So Shannon, if Jane was writing up with one of the people that showed up on, if you could flip to the next screen, saying Jane represented the buyer's agent, she would end up, when she wrote the deal up for Shannon, she would end up on number 15. She would say buyer represented by the buyer broker. And then Shannon, she would indicate that the seller represented by Shannon, the listing broker. And Jane's information would go on the left side with Best Choice Realty. And then Shannon's information would go on the right side with Best Choice Realty. Best Choice Realty, if I would be considered a dual agency. So I have an obligation not to disclose confidential information between the parties unless authorized to do so by a court order. But Shannon and Jane represent their respective parties. So in that case, it's not considered dual agency in the open house circumstance, as long as Jane has a buyer agency agreement. So she must have a buyer agency agreement to actually represent that buyer. And if you were working the open house, Jane, hopefully you have a buyer agency agreement that you have tucked away before you actually put the contract in front of somebody. But that would be how you represent a buyer in an open house opportunity. The agent doing the open house is not, typically most of the listing agents, I don't see them actually doing their open houses. They actually have a buyer's agent that sits the open house. But just realize that that is not a dual agency situation unless you're the listing agent and you are doing your own open house with no buyer's agent there at the property. Okay, so if you did, so say Shannon did represent and she did her own open house without Jane helping her, then Shannon would be a dual agency and she would need to get permission, and there would be permission granted in the listing agreement. The BCR 1A would have granted her permission. Shannon would just need to make sure before she writes the offer that she includes a buyer agency agreement that spells out her duties as a buyer's agent. And she submits that information as a dual agent. So that would be the open house opportunity where you could potentially run a dual agency situation in the state of Washington. But let's go to the next scenario. The next scenario is all about, I hear this a lot and it's like a bad word. It's like, no, 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 we should not be using the word facilitate. We don't facilitate in the state of Washington. We have very specific duties as an agent. So if your client, let's say that person that came through the open house was like, Jane, thank you so much for, showing us the open house, but can you just write it up for us? Can you facilitate this transaction? Maybe it's the neighbor next door. And Jane needs to respond in that scenario and tell that buyer, unfortunately, I cannot facilitate. I can write it up, but you would be unrepresented. And there's duties and explaining that law of agency to that buyer and helping them understand what your duties are and why you should represent them in the transaction would be important. So be very careful about those two words, writing it up and facilitation. Usually that happens when a family member gets involved, where they want you to kind of cut your commission. Be very careful about how you represent or how you write things up. So that would be, if somebody was just going to write it up where there was no agency duties, you would want to go to the next slide, Shannon. If you were not going to represent that party and in essence write it up, you would make sure that that buyer was unrepresented and the seller would have representation by the listing broker. When you have a situation where you're writing up on legal documents, you need to, and the client is unrepresented and you're touching those documents, you have a duty, because you have touched that paperwork and actually prepared paperwork. You have a duty to make sure that that buyer, even though they're unrepresented, has been properly given information. I always, whenever I represent somebody where I represent the seller and the buyer has asked me to write it up as an unrepresented, I always make sure that there is an attorney review contingency listed in the addenda line, just to make sure that they have had a chance to talk with an attorney. And then I've done a good job at representing my seller. So yes, you can, but that would not be a dual situation. We don't want to have that happen. Okay, let's go to the third scenario. If you can go back a half a step, Shannon, that would be great. The last one would be a co-listing agent. So let's just say Shannon and I, let's say Jane, let's just keep it simple. Let's say Jane and Shannon are a co-listing situation where Shannon's like in the office Monday through Friday. And she's like, Jane, can you help me? Can you co-list with me on this property? And the seller agrees for the co-listing. They actually know when you took the listing that Shannon and Jane are going to be displayed. Their pictures are showing up on the flyers. And then Jane goes ahead and has an open house, and where Jane and Shannon are both representing that seller. Can Shannon and Jane represent the seller and the buyer in a dual situation? Can Jane be removed as the co-listing agent and then represent the buyer in that situation? And the answer is yes, you can do that. You just need to make sure your paperwork matches that relationship. It requires the designated broker and the seller to agree to remove that co-agent from the contract, from the listing contract, and remove so that Jane can represent the respective party so that it's not a dual agent. That would be the best, so that everybody has their proper representation, but that is okay to do. If the seller, or in my situation, I'm like, Jane, you know too much about the seller situation. I don't agree that you guys should be a dual agency in this situation. I will basically assign another buyer's agent to represent that buyer, and Shannon and Jane will represent that seller. So it has to be permission granted in writing from the designated broker and from the seller in order for Jane as a co-agent to be removed from that situation and then applied as a buyer agent. So if you have those situations, and we have had that come up, just reach out and call me. I was on vacation. I remember when I was on vacation a year ago, when one of our Chinese speaking brokers, she had that very situation happen where she had another agent representing her in a co-situation. And it was nice because that we removed that co-agent from the equation. We got the seller's permission. And then that buyer, who also spoke Mandarin, could be represented by a buyer's. And there was no confidential information that was shared because of the situation of the co. And that was something that I had to make a determination on based on the knowledge that was given to the seller and the involvement by that co-agent. So I have a greater obligation to manage those transactions when it comes to dual situations. But those three are common scenarios that we run up against quite a bit, actually. Okay, so let's go to the next slide. and I'll kind of explain the dual agency. It's described. People are like, can we do it in Washington? Yes, it's allowed in Washington. It's described in the law of agency, which is our duties. And Section 6 is all about the dual agency situation. So as you're having more conversations, again, it's front and center in our new listing agreement. And also the Northwest MLS, when they put their listing agreement together, it's described dual agency it's broken down on how you're going to be compensated. But if some of your sellers have questions about dual agency, you might want to reference them or have them reference Section 6 in the pamphlet that you would have supplied to them right along with that listing agreement that they're signing. So it's in Section 6, it says prescribes the additional duties of a broker representing both parties in the same transaction and requires written consent of both parties to the broker acting as a dual agent. So that's the rules, that's the RCW code referenced in 18.86.060. So compensation, it's right there in Section 8. So really, there's only 2 sections you have to really kind of concern yourself. How do we get paid? Again, compensation is described in Section 8 with the cooperating real estate firms. It allows us to collect compensation from one party, from both parties, from even referrals. But Section 6 is probably the most important part. If you have not read that section and you do want to act as a dual agent, you might want to kind of I highlighted the key parts for you guys tonight. You know, that written consent is probably the most important part. I see a lot of brokers, oh, I want to be a dual agent, but they don't get the buyer agency agreement signed. That's a violation of RCW code, and you can be fined for that because it's a violation of Section 6 and of the RCW code. But when it says written consent must be done by both parties. It must include a statement of terms of compensation. That's why you need a buyer agency agreement if you're going to represent both parties, because that deals with that terms of compensation in the buyer agency agreement. The other part on Section 6 that talks about no action that is adverse or detrimental to either party. So if you're like feeling, ooh, I'm a little nervous about representing the seller and the buyer because I know too much about the seller situation, you may want to opt not to do a dual agency when you take the listing. You might want to just zero that part out in that dual agency section so that the seller feels comfortable signing an agreement with you, knowing that you're not going to be in a double dipping type of situation with a potential buyer. The other thing that you want to discuss is that they need to seek legal advice on matters relating to a transaction that are beyond the dual agency expertise. So if they have obviously concerns about that, that's where an attorney would typically get involved in a dual agency situation. Confidentiality is very, very important. In fact, confidentiality, it stays even after the close of escrow when it comes to confidential information. So that is kind of a duty that kind of carries forward. You're not obligated to seek additional offers. So for example, there's some limitations. So if Shannon and Jane were basically representing in a dual situation, unfortunately, we cannot go and get additional offers to come in because we're in a dual situation. So there is some limitations to dual agency. And also Jane, if she represented, I had a buyer agency agreement in a dual situation, she would not be able to go and get more contracts written, you know, to kind of be in backup position, things of that nature, because of that dual agency relationship that was agreed upon by the parties. So those are the kinds of things that are described in Section 6 of the dual agency pamphlet. You may want to go in and highlight it, especially if you're going to have more discussion with your sellers about dual agency. And then the duration, and we talked about that broker owes no further duty after the termination of the agency relationship, except for accounting of the monies, making sure that we give them their closing statement, and also not disclosing confidential information. That carries forward. The rest is, you know, we don't need to worry about, but that's pretty much confidentiality is kind of a key thing. And so sellers that are very concerned about confidentiality, they may be more concerned about dual agency, and they may ask you more questions about that. And you might want to direct their information or direct their attention to Section 6 on that law of agency pamphlet. Then, you know, it comes down to some of our brokers, I hope it's not you, think that, okay, as long as I just provide this receipt in my transaction file, I'm good. That's my dual agency. You know, I've disclosed that I'm a dual agent. That does not work. That does not establish agency, nor does it, you know, if you have not provided the actual pamphlet, that could provide a problem for you. This is just a receipt showing that they've received it. And we do ask, it's mainly used for proof that you delivered the law of agency pamphlet to your client, but it's not proof that you are actually representing that buyer or that actual seller. The actual buyer agency agreement and the listing agreement do that type of that type of arrangement, or who represents who. It deals with that. This is just mainly a receipt. Also an old practice. I want to make sure you guys are not using, some of you older agents. Form 42, we don't use that. That is not used to establish agency. You would want to use a buyer agency agreement, or you would use a listing agreement, one or the other, and then confirm that they've received the pamphlets or the disclosures with this receipt. That would be the proper way to do it. Okay, let's go to the next one. So to recap, I told Shannon, I said 10 minutes. I'm a little bit behind, but not bad. The recap, or the pros and cons. Dual agency is discussed in our listing agreement. I will go ahead and show you that section before we wrap. You must have a buyer agency agreement if you're going to represent both the buyer and the seller. So typically you'd have a seller agreement, maybe not. Maybe it's a first sale by owner and you're actually representing that seller with a seller representation agreement, and you're kind of marrying those two people up. You have to have, in the seller representation agreement, Form 47, you also have to have our 41A as well, a buyer agency agreement, if you're going to represent both parties. We have had some situations where we've had to go back and do some education for those people that handle off market or where they represent seller representation. Those types of situations, it requires a buyer agency agreement to represent both parties. So let's watch that. It is heavily audited by the Department of Licensing. In fact, we are being audited with our Spokane office right now. It's the first year in the business. And so as you would expect, the Department of Licensing has pulled up, they want to see 10 files. Well, we've done 10 transactions in our Spokane branch. Guess what, you guys? The first one they asked for that they're looking at is the one where we represent both parties, a dual agency situation. So you can expect that anytime you represent a seller and a buyer, the Department of Licensing will most likely look at your file. They will look at how you filled it in. Did your earnest money get deposited on time? Did you properly represent? Was there communication between the parties in terms of price? Did you give away some confidential information that you should not have given? That type of information is the stuff that the DOL is looking for, and they will be auditing each of the branches in terms of dual agency. Also, something to keep in mind, it is considered two transaction sides, meaning if Shannon represented the seller and then she also represented the buyer, she would get credit for having two transaction sides on our MLS statistics. But there is double commission, or double compensation, right? We even have a little typo there on the slide. There will be two compensations offered. She'd fill out her Form 40, her compensation authorization on both the buy side and the sell side. So she would get paid in two different, sections, which also means our fees at Best Choice Realty would also take an effect for both sides of the transaction. Many of you didn't realize that maybe, or didn't know that. Now you know that it is considered two transaction sides, and it is heavily audited by Department of Licensing and all of the regulatory bodies. It is the most risky representation. The school of thought here is really not to be a conflict of interest. If you feel like it's a conflict of interest, the best course of action would be to call me as a designated broker. Anytime I represent a seller, I am considered a dual agent because I have access to transaction desk, I have access to paperless pipeline, I have access to all of the files for review purposes. Anytime one of my managing brokers is also on one side, that also could be seen as a dual situation as well. So if you have a managing broker's license or a designated broker's license, you may not realize it, but you're actually in that dual agency kind of category. You may want to talk with me if you're concerned at all about conflict of interest and how you should structure something if you are in in that type of category. Teams kind of watch that, because a lot of times the team member or the managing branch manager of that team or that mentorship could potentially be a dual agent as well. Again, the best course of action, if you're concerned about that representation or that conflict of interest, it's best to just call me and say, hey, Rochelle, here's my scenario. What do you think I should do? And I will advise you, because ultimately the risk falls on my shoulders when it comes to audits, litigation, court cases, all of that. It all falls on my shoulders. So I want to have as less risk as possible for the brokerage and for you. You have dual agency duties. So you can't just write it up or facilitate a transaction. In the state of Washington, the law of agency is the law of what we handle for real estate. So you do have agency relationships that are created, and you can't just use forms that are copyrighted forms. You can't just give that copyrighted forms to somebody and they can write it up. That's not okay. You can get yourself in trouble for that. The devil was kind of funny. I had to kind of have fun with it. I love the double commission, where a dual agent is the devil. I mean, it's kind of the devil in disguise sometimes. There were some other things I saw, emails that were created. Of course, I experienced this where I'm up against multiple offers and the listing agent basically stole my client away from me. That has happened to me. And it's just like the devil right there on the left side of the visual. They run a very, very tricky kind of situation if you're going to be playing in that arena. Have I done dual agency? Absolutely. I do dual agency all the time because of my designated broker title. So I have to be very careful about how I confidentially hold things for the seller and also for the buyer, and what can be said and what can be given at various times of the transaction. Let's go to the next. Shannon, if you can go to the listing agreement, I want to show the part of Best Choice Realty's listing agreement that describes dual agency. It was not really described before, and I like that we have put some time around it and also put some language around it. Whether you use, you're working with a listing agreement, all of the Washington state contracts have been added this area of dual agency into our listing agreement. So there you go. There's our listing agreement. And if you scroll down on page 1, if you scroll all the way down, there we go, Shannon. There's the compensation section. And a lot of people are like, well, what do I fill in on 4B section I? You'll notice I don't cover that in my other little video. That right there is if I'm going to represent dual agent, if the listing broker is a dual agent and represents both seller and buyer, then the buyer brokerage firm compensation paid to the listing firm shall be blank or equal to 4B if not filled in. So if you're not going to be doing dual agency, then you're going to want to go ahead and zero that out. If you're going to do dual agency and you don't fill that part in, it's going to be whatever is in the section B, which would be how you get paid for representing that buyer. So if it happens to be 2.5, it would be 2.5. You're going to carry that forward. So if you're going to fill all the spots in, whatever you put in 4B and your seller says, yes, I'm okay, Shannon, for you to represent both me and that potential buyer, that's where you would end up negotiating that dual agency section. So we are having sellers right now, because it's in the first page of the contract and it is described, they are negotiating with their listing broker and saying, you know what, Shannon, since you're going to be doing less paperwork, would you be okay doing it for less? And that is something that is separated out. So maybe she does it for less, maybe she keeps it the same, or maybe she doesn't do it at all. That needs to be described in 4B in that section I, where you need to indicate an item. If you don't fill it in, it's going to be whatever you put in that 4B. Okay. Let's go back to the case law real quick and I'll wrap up with the case law. So just to kind of bring my point home, Shannon says this is kind of the icing on the cake. When we have a situation where we go to court, when we are suing a potential seller for performance, we just got the conclusions of law where it says the real estate licensing law provides that a real estate broker is subject to disciplinary action for buying, selling, or directly or through a third party in not disclosing in writing their either I'm licensed as a real estate broker or also who they represent, that you can be sued for that. and it's subject to disciplinary action. In this case law, it was undisputed that there was failed disclosure that was done. So that was part where the defendant won. But it was interesting because there were other areas of the case where if we would have done a better job at providing disclosure with the buyer agency agreement, with disclosure that our broker was also a licensed real estate broker in the state of Washington, who was a party to this particular company, I don't know if the court would have sided the way they did. But as it was, the parties went their separate ways. The buyer had to pay for their own attorney's fees. The seller had to pay for their own attorney's fees. And I was a witness to the case where I had to basically verify what documents were put in writing, what was actually disclosed. And it says the conduct was unscrupulous. He hurriedly formed a company. The plaintiff seeks to enforce the identified buyer about listing broker and selling broker. Was that properly disclosed on who was a member and who was not? Although the real estate licensing law is primarily administrative and subjects a licensee to disciplinary action by the DOL, there was case laws that provided some statutes and some case law. The court held a real estate broker's agreement to share its commission with an unlicensed person violated the real estate licensing law. So again, we had to be very transparent about what compensation was owed. It says, in addition, number 8, as both the listing and selling broker and a member of the buyer had a conflict of interest that he failed to disclose in violation of the real estate agency law, which requires, there's the 18.86.060, to timely disclose to both parties any conflicts of interest. That should have been disclosed at the onset, before the purchase and sale agreement was even drafted. And that's where the judge had a problem with it. Number 10, it said, there was unclean hands. When you talk about unclean hands, it's kind of that description of like having a conflict of interest. Because there was unclean hands, because he failed to make a clear written disclosure of his status as the buyer, and that he was a licensed real estate broker in the state of Washington, and that he was also a dual agent. There was reasons for failing to use the form are not credible, while he did provide some information that was consistent. So there was some sort of, on the first page of the purchase and sale agreement, there was some kind of he provided information in a piecemeal fashion without specifically bringing it to the client's attention. And so therefore, the court finds that there was never a clear disclosure, written or oral, of his status as the buyer. The plaintiff was not clean, requiring the court to deny the equitable remedy, so we didn't win the case. And then if we go down to number 13 and 14, this is where I got involved. So here I'm specifically named. It says in the line 15, it says, from Miss Wilhite's testimony, which was credible, it is clear that she initially remained committed to the sale of the property to another customer, but was understandably unwilling to continue working with her. She was basically, I just verified that the purchase price and that the seller lied about her reason for terminating the contract. Because she wanted more money. She was very greedy in what she was trying to do. And so because of the unclean hands by both the seller and the buyer, the case was basically settled, and everybody had to go their separate ways and pay their respective attorney's fees. And the judge pretty much made a clear line in the sand and said the case is not going to go forward. So it's unfortunate, because I think in this circumstance, if our broker who was suing the seller for performance would have taken the time, and he knows this, and actually put the proper documentation in place on who represented who, and he had a buyer agency agreement, and he had also a proper disclosure of who he was and the entities, we never would have gone to court, and this deal would have actually closed for the agreed upon amount. But because there was some funny business and a not proper disclosure, that's how we ended up in court, and we were in court for quite a long time. This is an ongoing case that has been ongoing for many, many months. So that's what I wanted to wrap with. Was there any questions, Shannon, that I missed as I kind of talked? Oh, you're on. There you go.
There you go. I think I'll just reiterate that I think it's important just to disclose always, whatever it may be, just to make sure that the consumers are aware. It's better to have shared who you're representing than to have just hidden that fact, material fact.
Right.
One of the questions that we had that came through, I know we've got a hand raised too. We'll get to that one after this first question. Would it be typical in an open house scenario for a buyer agency agreement to be completed specifically for the subject property? Or would it include any future properties as well that may or may not be written up by that broker that is representing the seller?
It's a great question.
Yeah. So how would you handle that, or how would you approach that? I think quite simply, the Best Choice Realty buyer agency agreement and listing agreement both covered those types of scenarios where you get to indicate the term and length of the agreement. So if you're encountering that situation, and just keep that in mind, ours are a little bit more exhaustive in terms of what they will cover.
Yeah, but that's a good point though. I mean, could you essentially do it for the, for that particular property? Yes, but like, why don't you just adjust the term, right? Let's just, back it up. Maybe it's just a 3-day term of a buyer agency agreement, right? Until you negotiate that position. I think that's a great idea, but if you did need me to modify the buyer agency agreement for that specific property address, I'm happy to do so, but I don't think it's necessary. I think that you guys do a lot of work as a buyer's agent when it comes to what if it happens if that falls apart, that buyer agency agreement, or that they walk away on inspection. Then if you had a buyer agency agreement with that specific term, longer, that not for that property, but for other properties as well, it could be argued that basically you have an agreement that will last for the term of that complete transaction, or finding them another property that may be better suited for them. So I'd rather work on the term than work on the address, I think, Shannon, in that case.
Yeah, I think too, most of the people that are using buyer agency agreement, and there are a lot of agents that are using buyer agency agreements. I mean, that they're establishing an agency relationship, but that also just establishing a relationship in general too, with that particular buyer that's coming through for an open house. So I would say that even if the house didn't work out for whatever reason, inspection, financing, whatever, would they use that agent to go look at other properties? It's actually very likely that they would in that scenario if they have that relationship and rapport already built.
I mean, but to make yourself feel, I guess, better, I mean, could you go back and take their name and their phone number down? And when you prepare the paperwork for electronic signature, which is most of the cases, 90%, right? They're like, hey, Shannon, this is what I'm going to call you later after the open house. It's not like you're going to write the deal right there, right at the open house. So when you do put the paperwork together, just make sure you get the buyer agency agreement signed before you start drafting all the paperwork. I think that would be the appropriate time to place that. So do you need one right there at the open house? No, but definitely before you put a purchase and sale agreement together. Okay. Did that answer that?
Yeah, I think that answers that question. And for those that missed the first couple minutes of our call, dual agency is a hot topic. It's one of the top 3 issues that we have in terms of dealing with matters that hit Rochelle's desk for sure. But the DOL auditors, they will ask for buyer agency agreement. Don't kid yourself. If you're representing both parties, there's a reason that our brokerage has a good stance and protocol to ask for those buyer agency agreements, is because we know that we will be audited and asked for them from the Department of Licensing. So keep that in mind for sure. And then I think to your mention of the attorney review addendum, for those trying to figure out the form number for that, 22RA, if you're wanting to include something like that for an unrepresented buyer, or for sale by owner in that situation too. That's what Rochelle was mentioning.
Okay. And then also somebody asked me about E&O. Would errors and omissions insurance cover that case? It's possible in this type of situation that we just got done doing. The E&O was not something we were going to execute on just because of how the structure was done. But E&O, oh, I made a mistake. That's what errors and omissions insurance is for. The deductible is still very high. So it's like, you want to try to avoid having to execute the E&O policy, but actually the only E&O policy or only insurance claim that I've ever had in my entire career was a dual agency situation. So there you go. I mean, E&O is something that it is covered in our policy. But again, just realize, gosh, do you really want to have to pay a deductible, a high deductible, if you actually had a claim, or do you want to just do your paperwork right from the very beginning? So yeah, kind of look at that type of situation. If you're kind of wondering, oh, I'll just kick in my E&O. No, that's not the way to kind of think about this. And jack the rates up for everybody on the E&O.
Yeah, and we had one more question that came through. So when you write up a contract for a buyer and you don't have a buyer agency representation agreement, what do you need to do? What would you say in response to that, especially as we're transitioning with the new forms?
When you run the risk, if you don't have a buyer agency agreement, if it's an off market or for sale by owner, that the seller could just cut you out of the deal altogether. So that's why you want a buyer agency agreement, is because you don't want them to go off the side and just negotiate something without you. There is that agency that's established. And if you put a 41C together, let's say you check the first box and you don't check the second box because you have no buyer agency agreement, there you run the risk that that seller might cut you out of the deal. You know, they might come to an agreement and not have to pay you anything because you have not done a good job of putting that agency agreement in front of them. Did that answer the question? Or again, I talked for 30 minutes, so my head.
Yeah. I think they're referring specifically to where the deal that is already under contract.
Oh, got it. Okay,
yeah.
so it's like already under contract.
Yeah.
And you didn't have a buyer agency agreement. What do we do then? Is that the question?
Yep.
And you represented both parties or just one party or the other?
I'm assuming both parties, but let's run under that scenario.
If you goofed up, the state does, you know, as far as learning, there is a little bit of forgiveness, I would say, with if it's your first time. If you want to call me or text me, oftentimes we can, if it is still pending, it's easy to go ahead and put that agency agreement in place, or to make notes on the file that we've had a conversation and educated you on that particular very important point. It's when it's closed already. It's not like I want you to go back in time and establish agency. We'll just have to make a note of that on the paperwork.
Yep. And I think too, I think my last comments for sure would be, it's kind of like the show Who Wants to Be a Millionaire, where, you know, when in doubt, it's best just to call a friend. And in this friend in this scenario would be Rochelle. So if you have questions about dual agency, or you're encountering it, or you've got someone that walks in and they're just wanting to write it up, or a family member wants to buy from another family member, they want you to handle the paperwork or something like that, it's best to call us ahead of time to make sure that we can write it up properly, so that you are best protected for sure.
Yeah, and we have people that are using that listing agreement and having really good conversations about dual agency. And so we've seen some really good creative things come through. And I think that this is kind of like why they decided to do this in Washington, is to make have more discussion about compensation and in those various scenarios, whether they're unrepresented or whether they're dual, and have that very upfront open conversation with their listing agent. So far, I'm very pleased with how well you guys are using the forms, and it will just, like I said, it will get easier and easier the more we work with them. So call me if there's questions. Have a great week, and we'll catch you next Monday. I believe we're going to be talking about transaction coordinators next Monday. That would be nice to kind of get some relief. So that's next Monday, and we'll talk to you then. Have a great week, you guys.
Thanks, you guys.